Another rule that's kind of important here is this idea of the four corners rule. It sits really neatly, I think, with the parole evidence rule. And the four corners rule is essentially that an exclusion clause can't protect from liability arising from acts that are outside the four corners of the contract. So again, Darlington Futures fit in that context to a limited extent. So it needed to be brought within the scope of the contract, but it was the relationship brought about by the contract that resulted in the damage applying. So an exclusion clause is unlikely to have been intended to apply to acts that are unauthorised or outside the four corners. And so this is TNT and May and Baker, which we'll have a deeper look at in a few slides' time, I guess. So what does the four corners rule say? Oh, this is a good example. City of West Sydney Council of the City of Sydney and West. So Mr. West parked his car in the council's garage. The contract he entered into required the production of a ticket before taking delivery of the car. A man fronted up, called himself Mr. Robinson, said he had lost his ticket. The attendant gave Mr. Robinson a ticket, and Mr. Robinson took Mr. West's keys and drove out of the car park. So the question before the court was, who's liable here? The exclusion is a standard type of exclusion clause where is it on here or I've got the answer on here? No, I've got a car that drove past quickly. No, I'm sorry, I haven't put the terms of the exclusion clause on. Question here was, does the exclusion clause, let's assume it's a broad-based exclusion clause, can it protect when the council's employee is clearly being negligent? So basically in this case it was held that the clause didn't apply to acts that aren't authorised or contemplated by the contract. The majority here was influenced by the fact that the attendant had allowed Mr. Robinson to take the car contrary to the terms of the car park's own ticket. So the fact that he had breached the terms of the contract in his act of handing over these keys, it made a mockery of the contract itself. If the promise is, I give you a ticket, I hold your keys, I only give your keys back to you when you come back with the ticket. If you don't keep that promise, having an exclusion clause that exempts you anyway, effectively makes a mockery of the contract. It actually ends up as the term has absolutely escaped me, an illusory term. Sorry, I'm just having a moment, seeing a moment here. Becomes an illusory term. The two terms next to each other had no effect. So in this particular case, the exclusion clause wasn't effective. And that's applying the four corners rule. But if there's no ambiguity, the common law will still uphold these clauses. So Nisho EY is the case here. This is the case that has upheld the principles in Darlington Futures. A clearly worded clause can exclude liability even if it defeats the main purpose of the contract. But it needs to be absolutely explicit. An unambiguous exclusion clause can cover a deliberate breach of the contract. So they can be pretty powerful things, and we'll come back to photo production shortly. What about a deviation though? A carrier can't rely on an exclusion clause if it deviates from what was contractually agreed. So this is again consistent with Sydney City Council and West. So in this particular case, Thomas National Transport, or TNT, and May and Baker, essentially TNT transports goods between Sydney and Melbourne. So what their contract says that they do is they'll take these goods on the highway, they'll get them to a point, they'll put them into TNT's warehouse, and then the next day they'll drive them out and deliver them to an address. All pretty easy. But what in fact happens is, of course, truck drivers are human and they live in their little houses wherever they live. And this particular truck driver one day, he drives the goods and instead of taking them to the depot, he just leaves them in the truck. I can't remember whether it's outside or on his property, somewhere on the outskirts. Bad day for this truck driver because there's a fire and the goods get completely damaged. So the exclusion clause in the contract says if goods get damaged on transit or while they're being cared for by us in our warehouse, we've got no liability. So the question became, did that exclusion clause protect TNT in this scenario where the goods weren't held in the warehouse? So think about City Council and West, a deviation from the terms. What do you think? No, exactly. So basically in this case we had negligence. Oh, sorry, I've gone on to the next slide without meaning to. I thought I had the ratio there, but basically we've deviated from the contract. We can't, the idea of the commercial understanding was if the goods are held in TNT's warehouse, we've got an understanding of what that means. That means there'll be a security guard there. That means if they're, refrigerated goods, they'll be kept in a refrigerated space. That they'll be protected in some way. But actually keeping them, that's quite different from keeping them in the truck at somebody's house or outside their house. And so that's not protected. What about negligence? So courts have on the whole taken the view that it's inherently improbable that one party to a contract should intend to absolve the other party from the consequences of his own negligence. But again, if you are very clear and unambiguous as to the terms, then it is possible to have an exclusion clause that does exactly that. But we need to see a clear intention. And what else? We need to the most effective way to do it when you're drafting is to use specific language. So to specifically refer to the potential for negligence and be clear that that is included in the scope of the term itself. But if there's no prospect of liability without negligence, general words themselves might be sufficient. And this is the case I was thinking of Shoe Lane earlier. When I mentioned Shoe Lane, this is the case I was thinking about. Davis and Pearce parking. That is really hard to say. Much easier to write down. So in this particular case, it's an oldie but a goodie. Pearce parking ran, not surprisingly, a parking station. Mr. Davis came and parked in the parking station. He got a ticket. It was called a parking check. It had some terms on it which said this must be exchanged at the office before the motor vehicle can be obtained. The car is garaged at the owner's risk and the parking station will not be responsible for any for loss or damage of any description. So keys are handed. Where are the keys? Sorry, let me remind myself. The keys were then left with the attendant. Actually, the whole car with the keys were left with an attendant who was going to go and park it. And this attendant left the keys in the engine of the car. And somebody came and took the car. So, in fact, here he is, keys in the car, bad guy comes, the whole thing runs away. The things I do to amuse myself and you. So this class is not at all amused by my animations. It's like, you are like my son, you just give me nothing. Nothing at all. You just like, do not reward bad behaviour by anything. That's, I can see how this works. So what happened? What do we think? This particular case, what happened? I've given you so many clues. You think they lose? Who's they in this case? the parking station, Pearce, okay? So you don't think they should win? Okay, that's interesting. Don't think they should win. So think of your reasons why that might be the case.
It comes down to the term of any description, whether they've clearly stated that negligence is included.
Well, this case I've already told you is an authority for this idea that if it's pretty hard to imagine loss or damage without negligence, then the broad terms might be enough. So you're right, they did win. They did get to uphold their case and uphold their clause. And the reason for it is ultimately economic. And to me, it makes sense. I think a bad result for Miss Pearce. Davis, I should say, lost his car. But essentially the judge is saying this is actually about allocation of risk. And it really comes down to who bears the risk in relation to this. So the council is offering this facility at a relatively low price. And if it had to factor in the costs associated with all loss or damage, potential loss or damage to vehicles, that cost would go up exponentially. Where actually it makes sense for the owners of the vehicle to insure them. That's an appropriate allocation of the risk. And it's better to have cheap and available parking and insure yourself than it is for the insurance risk to be borne by the parking agent. So it was held that the exemption clause should be construed as excluding liability for negligence, that the clause was sufficiently worded to protect Pearce from liability for negligence, and that Pearce wasn't liable for the theft of the car. The quote here, which I think with those colours is really difficult to read. Let me just have another look at it. Oh, the little car went past, how cute. No, gone too far. I'll have to come back again. Let me see if I can make this bigger. Nah, it's not going to do it. The defendant was making a very small charge for taking the custody of the goods, which are or may be of great value. He is likely to intend, and the plaintiff would reasonably expect him to intend, to protect himself against, inter alia, amongst other things. Judges like to throw in some Latin every now and then, just to show they went to law school. So protect himself against, inter alia, a possibly very heavy liability arising from the negligence of a servant. Either party can insure, and such a clause can reasonably be taken by the plaintiff to mean that if he wishes to be protected against the loss or damage at all, he must insure. Chief Justice Dixon.
They cite Darlington, because it's similar to Darlington.
It's 30 years before it though. Yeah, so they didn't know. Can you imagine how hard it would be if we made you cite future cases? Like, some of you have real troubles like citing the ones that are in the past. Like, citing the ones in the future is just a whole new level. But I'll be impressed if you can do it. I don't remember off the top of my head. What about a deliberate breach? Get negligence. What about if you do something that breaches the contract? In what circumstance could an exclusion clause be broad enough to cover that? Courts have essentially tended to require very clear words before an exclusion clause will be construed as excluding liability for a deliberate breach. So it's hard to do, but it's not impossible. Photo production and secure record transport is a good example. So basically what we have here, these three pictures are supposed to remind me of what happened. Secure record Transport Limited, let me get this around the right way. Secure record provided security services to factory, building, warehouse that was owned by Photo Production. Security guard, he was not hired negligently, good guy, knew what he was doing, had the right kind of experience, but the place was really, really cold at night. So against the rules and in breach of security clause contract with photo production, he started a little fire to keep himself warm. Deliberate breach of the contract. Fire got out of control, the factory burnt down. There was an exclusion clause that said security clause weren't liable for any damage, loss, howsoever caused. Let me see if I have the words of it here. The exclusion clause in the contract meant that they were not liable, as it said, under no circumstances would Securicor be responsible for any injurious act or default by any employee unless such act or default could have been foreseen and avoided by the exercise of due diligence on the part of Securicor. So ultimately the court found in this circumstance, have I got the finding on the next one? No. So in this, I'm trying to reduce the number of slides, but then I can't remember what I put on the next slide or not. So I'm trying to make life easier for you, and it's harder for me. In this particular case, the court said, well, Securicor didn't hire negligently. It did its due diligence in relation to its employees. It wasn't reasonable to foresee that the place was so cold that this guy would set a fire and it would get out of control. It had a broad exemption clause, and again, it also turned its mind to who bears the better risk. They're insured, both parties are insured, but it makes sense that it's the owner of the premises that has the insurance for that kind of incident. So again, it all just goes to putting up our insurance claims at the end of the day. And when you think about these cases, these are very rarely cases where the individuals are taking the actions directly. It's actually one party's insurance company against the other party's insurance company acting in that stead.
So in the exclusion clause applies?
It was successful. So Securicor were successful.
This is the reason why there's so much statute that covers this area.
In relation to consumers in particular, where there is no very good bargaining power, yeah, it is. Because we can see sensible decisions in relation to the allocation of risk between two parties of equal or similar bargaining power. That it makes sense for them to go through a risk liability regime. And we're talking about some small contracts here, but if we're talking about very large contracts, for example, say the building of this East-West Link, massive contract, billions of dollars, insurers will be at the negotiations as they work out the liability regimes. Okay? Because everybody's looking to make sure that they're in the best possible protection regime. So a lot of what happens here is commercial, and our job is actually to document it, the difference between agreement to verb and agreement to noun. So the courts look at the noun in order to understand what's encompassed by the verb.
Yeah, I just imagine over time people really taking advantage of that. Like I think of that guy with the car with the keys in the car. There's no reason like you have someone on the side saying, "Look, I've just left the keys."
Well, there's no allegation here of fraud or of criminal conduct or anything. It's negligence, is what was. So we have to go with the facts that we've got. But yeah, look, I can see your point. I don't know, for whatever reason, that case always makes me think of Ferris Bueller's Day Off, and they leave the car in the car park, and the car park attendants are like driving it all around Chicago. Yeah. It is like the best movie. Anyway.
Or the Big Steel.
Big Steel.
Just right.
I haven't watched it. I'll put it on my list though. So, exemption clauses need to be interpreted the same way as any other term, regardless of whether a breach has occurred. They're about the allocation of risk. The scope of an exclusion clause is determined by examining the construction of the contract, understanding how to read the contract. Now, we don't do a lot about reading contracts here. Happy to give you, I made massive notes about the one stage we're going to add them into this subject, but we do them more from a drafting perspective in advanced. We can't run out of time, I think, otherwise. But learning how to read contracts is similar to learning how to read statutes. So there is a formula to it, there is a set of rules. I think the craft in being a contract lawyer is learning how to write them, how to use those rules to your advantage. I'm not thinking about get somebody on the side to steal cars particularly, but not that kind of advantage, but being very cognizant that when you're allocating risk, we need to be very clear on what is intended and thinking about what that means and being very consistent in the way the contract. So what are our key principles here? Fundamental breach is a rule of construction and not a rule of law, and freedom of contract still trumps any other considerations. So this comes out of, so at first instance, sorry, I'm jumping the gun a bit. At first instance in photo production and security law, Justice Denning came up with this idea of a fundamental breach, that there might be some fundamental breach of the contract that affects the workings of the exclusion clauses.